option. Right? In the case of a landlord, or a tenant who breaches, there's an obligation to find another tenant. In the case of a holdover, where a client won't move out, a tenant won't move out, instead of using self-help, the modern trend is to use the judicial process. And we can debate whether these decisions are right or wrong as a matter of common law. I mean, they're usually made up as a general matter. But the important point is, at the present day, in the modern trend, landlords have special obligations to their tenants. They have duties to mitigate, they have duties of care, and they can engage in acts that are considered violent. Okay, I finally got my camera working after that little monologue. It takes forever. Okay, so any questions on that? No? Oh yes, Kendra, please go ahead. I will get there in about half an hour, I promise. I'll get there after we do the first case. But the short answer is it varies wildly by state. Some states are closer, some states are longer. All right, so where did I finish off last time? Are you next? Okay, you want to give the facts, please, in Berg versus Wiley?
And the lease provided a 5-year term with the terms that Wiley wouldn't make any structural changes.
Okay, very good. So let me just, you're right, let me just pause you for a minute. This is a commercial lease, and that does make a difference. This is not for a residential, this is for a business. And it was a lease originally for a pool hall, and then ultimately became a lease for a restaurant. And then Natalia makes an important point. She says that the lease says that you cannot make any sort of structural changes to the property without permission. And if you're a landlord, this might be a term that you want to respect, right? Natalia, what's another important term? I'm sorry, is that Natalia? Oh, who's Natalia? I'm sorry. I have another. Oh, you're over there. I just saw you 5 minutes ago, didn't I? I'm sorry. Here. Changes. Okay. What's one of the other terms that was important term of this lease? Okay. What else were they obligated to do in terms of the lease?
They bear all costs.
What else? The other one? You think of one more? And how are they required to operate?
Operate the restaurant in the Lockouts.
Yes, there it goes. Okay. So there were some terms in this lease that are important, right? One is that they can't make any alterations to the structure without authorization. That the landlord has the right to retain possession. And the third one, which Marcelo? Very good. Yeah. Thanks, Andres. Right. So if you imagine you're running a place and they're running a restaurant and they let it get dirty and there's insects, right? And rodents, ill, right? And various other very bad things. You don't want that in your building. So one way of ensuring that, this doesn't happen is you say you're required to maintain the premise in a lawful and prudent manner, which I suspect what they're getting at is if you fail health code violations, I can cancel your lease, right? I think everyone agree with me. That's probably what they were getting at, right? That if you're not up to specification for health code, we can shut down your business. Because first of all, who wants an out of code business in their building? No one. They're not going to pay rent. They're going to be shut down. Just indeed what happens. More importantly, who wants a dirty, rodent, rat-infested thing in their property that's going to leave lots of bad stuff? So these terms were put in the lease quite deliberately. So Justin, what happened? Was this
alleged state of disrepair with health code violations?
Yeah.
So Wiley determined for 2 weeks to They gave Berg notice that she violated lease items 5 and 6 and gave her tools to fix everything.
Well, what did the health inspector say?
The kitchen was unclean.
And then what deadline did the health inspectors give to the restaurant?
June 13th.
Ah, so see what's going on here, right? The health inspectors come in and say you have to be up to date, up to code by a certain date. And then the landlord's like, oh, I got this, right? I also find that you're in breach of the lease, come to code by a certain date. Now, Samantha, do you think that the landlord expected her to bring up to code? No. Did, Samantha, be honest, do you think that the restaurant owner intended to make the repairs and bring herself up to code? Probably not. Why do you say probably not? What evidence we have in the record that she probably didn't intend to bring herself up to code?
She kept operating the restaurant without closing it.
And then what happened the last day that she was required to come to code? Her employees. Right. You see the restaurant closes for remodeling, and they never reopen. Right.
Like, you go there and then you notice that the quality is going down. So then all of a sudden you talk about the restaurant again, like somebody, then all of a sudden it's closed, and you're like, oh, they're gonna open soon, and then 5 years later, oh, they never opened.
Yeah, so you remember the 59 diner? There's one right by 59 and Shepherd. It's been closed for remodeling for what, 2-3 years now. Yeah, you go there. There's it's right by Trader Joe's, right? So very often things shut down for remodeling, they don't reopen. So this woman, she dismissed all of her employees, and casually then she put a little sign in the window saying closed for remodeling. Yeah, right. So Kelly, you're the landlord, right? You see this happen. She puts a remodeling sign up in the window, and all of her people are being fired. What do you assume is happening if you're the landlord?
I thought she was going out of business.
She's going out of business, right? She's going to shut down. So you're the landlord, Kelly. What do you do?
I try to find another tenant.
Try. Well. How can you find another tenant if she's still in there? Before you find another tenant, you got to take care of business, right?
Okay, well then I should have gone to the courts, but he went in a different.
No, he did not go to the court. So what did the landlord do in this situation?
He went there, attempted to change the locks.
He changed the locks. So, what does that mean? Has anyone ever had the locks changed on them? I don't know. It's a very violent act, right? Like, you ever, like, this happens to me. Sometimes I'll go home and then someone locked the deadbolt, right? And I'm turning my key and I can't, like, what the hell's going on? And that's a scary thing. I was like, what just happened, right? This happened to me. I go back to the car. And you try and open the door and the locks don't work. That's a very jarring thing, right? But Dylan, it gets worse. He didn't just try and change the locks. What did this guy do? Very weird stuff. He did a little acrobats, yeah.
Like taking panels off?
But yeah, what did the landlord do that's a little bit strange? A little Spider-Man act there. I know you're guessing, but you're actually right. What did he do? You actually took my hint well. Yeah, there it is. Yeah. So apparently, he tried to change the locks. I don't know how this works. Can you hang from an awning? These things are very fragile. I don't know how this operates. Okay, whatever. So he's hanging from the awning, and like he's peering into the window, looking inside. And he looks in. He says, "Oh my God, they're stealing the paneling from the wall. This is valuable. I don't know, right? It's the 70s, right? So they're stealing the paneling from the wall." There's one person left at that. Off the walls, I guess is valuable. And then he starts banging on the door demanding admittance. Okay. So Berg calls the sheriff. It's like, this lunatic is banging on my door, get him out of here. And then Wiley calls the city police. I don't know what the hierarchy there, which is more important, but you know, they basically call competing police forces, right? And you can imagine the cop was like, what is this? Well, I don't want to deal with this stuff, right? Let them figure out their own issues. And the cops say, okay, I tell you what, let's keep everything status quo till Monday morning, and then we can deal with it, right? This is Friday night. We're not dealing with this crap over our weekend. Let everything sit quietly. Okay. Didn't quite go to plan, right? So Lance, what happened then on Monday?
Showed up like with the police officer to change the lock that she was on.
Yeah. So she was gone, and he went up and he changed the locks on her. And then what happened, Lance? After he changed the locks on her.
She found out and
She sued him for, what was the cause of action?
for lost profit and
And what was the major claim we care about here in this class? Lease. Then magically, right, Alec, when did he relet the apartment to someone, or relet the unit to someone else? Magically. No, not 2 years later. Oh, yeah, I'm sorry, I didn't hear it. You're right. 2 weeks later, right? So Alec, he kicks her out in July 16th, and he puts another 10 in there, August 1st. Alec, why do you think he was in such a hurry to get her out of there? The guy talk louder. No, but why was he in such a hurry to get her out of there? If you had to guess, speculate. Well, money, people. Money from quickly get another paying customer in there. Now, just think about this for a minute. It's not insane, right? She's in there. She's got 2 years left on her lease. She has shut down her business. I think we all agree she's going to walk away, right? Remodeling sign for 2 years. Good luck collecting rent from her. She's never going to pay up. Never going to pay up. So he says, screw this, right? I have a waiting customer who will actually pay me rent. I'm going to kick her out, change the lock, put my new customer in. So his action was, I think, from a financial perspective, for money, as Alex said, reasonable. But then, who sues whom, right? She wasn't sued for breaching her lease, right? For making changes and falling out of health code. She sued him. The person who screwed up at the outset sued the person who screwed up at the end, right? She sued the landlord for kicking her out. Now, we all know she wasn't going to pay her rent. But as this case turns out, she actually made out better than she would have otherwise, right? If she had just stayed there and done nothing, she would have for lost profits. But because he changed the locks on her, she actually made out better than money she would never gotten before. Is that fair? I'll let you guys decide that. But that's what happened. All right? So, I can't see the lock. Thank you, Stephanie. So walk me through, what was the course analysis here? Well, first off, let's make this point clear. Did she breach the lease? Does the court reach that question? Did she breach the lease? Okay. So she didn't keep herself up in code. She may change that permission, right? But Stephanie, the harder question is that when someone breaches a lease, what remedies are available? What, just as a general matter, what are the remedies available in case of a breach, a common law? Harrison? Syllable. That's it. So it's called ejectment. You also see it as ejection. Ejectment, ejection, it's the same thing. And that was basically a formal process to expel someone from a leasehold. That was a unique thing for a lease, right? Generally, someone has fee simple, they're there for the rest of their lives. If they have a life estate, they're there for the rest of their lives, right? If it's something with an executory interest, they might lose it. But with a leasehold, you can evict someone or eject someone for failure to follow the conditions of the lease, and that generally means a payment of rent. So you have two choices. You can go through ejection or self-help. Kendra?
So can you, if it was in here that it was unlawful, can you still try to eject someone if they're doing something illegal and unlawful?
Oh, you're asking if the lease didn't specify that illegal conduct was prohibited, can you still eject them? I think so. Yeah, I think if you find that someone's committing a crime, but it might be a little bit more difficult than you think, because how do you prove someone's guilty of a crime, right? Is this beyond a reasonable doubt in a jury trial, or is it really saying that it's actually right? Your friend next to you just got thrown to the bus, right? There. What are friends for? Rachel, did the health inspector find that the business had to be shut down? What was the health inspector's finding there?
The kitchen was just unclean and they needed to bring it up.
Yes, so if they had brought it up to code, would everything have been okay? Okay. So at what point, though, are you acting not in conformity with law? Is a mere finding, like a warning? Does that mean you're not in conformity? Or is like a final condemnation or saying, shut this restaurant down?
I would say like shut this restaurant down, because then they would be bringing in no profit and they wouldn't be able to pay rent.
Yeah, and I think that's probably right. Generally, with the law, you're given a warning saying you have X number of days to come into conformance with the law. That's not a final judgment of fault. I mean, for all we know, the person who's the health inspector could make a mistake and they can appeal it for various channels. So when Kendra's question is acting not in a lawful manner. Aha. And here's the issue. Why can a landlord by himself not decide if this person's operating in a lawful manner?
Don't they just want people to go to the court?
Well, no, that's true, but answer my question first, right? Why is a landlord by himself?
Oh, they don't want people to take like the laws and their
Well, not just law for ejection, but my question is more specific. How can a landlord decide, are you operating in a lawful manner?
Oh, it has to be objective?
Yeah. So this is an important point, right? If the landlord gets to decide what's lawful, that basically shortcuts the courts, right? The courts don't have a role in this. So one of the reasons why self-help is especially difficult in this case is because maybe she wasn't operating in an unlawful manner, right? Maybe had she given 2 weeks, she could have brought up the code. But she wasn't given that opportunity because the guy changed the locks on her. So she didn't have that opportunity. The other condition, though, oh, Julian, please.
What about the intentional destruction of the property?
Now, my next point. You're always like 5 seconds ahead of me. So, yeah, you always. So, Aaron, let me ask you Jolene's question, right? What about the other aspect? Did she make changes without the landlord's consent?
Without.
Okay, this one's easy, though, right? This is an easy case of breach, right? Julian, you're like 5 seconds ahead of me, right? Always. So she absolutely made changes with the wood paneling, whatever 70s decor, shag carpet, whatever it was, right? But she made change without getting consent. But it's actually not that simple. So Aaron, do you think the landlord actually cared that she made these changes?
I don't think he did. I think he was just finding an excuse.
Okay. So Aaron, let me ask you this question a little bit differently. Let's say, she goes to the landlord, hey, I'm putting up these new panels, right? He's like, yeah, whatever. And he basically doesn't give it permission, but he's like, whatever, I don't care. Does that waive the issue? Can he still complain about it if he didn't really object when he found out about it? there's a breach here. So once you have a breach, how do you go about dealing with it? Okay. So the ejection process at common law can be very time consuming. Why? You have to file a complaint. There might be appeals. It could take a fairly long time. At common law, you had what was called self-help, right? And self-help had a very specific meaning at common law, right? So Citra, when he changed the locks, right? Let's say there was, equipment, ovens and refrigerators and stuff inside the restaurant. Could the restaurant owner access all the equipment and stuff inside the apartment? Or I keep saying apartment, inside the restaurant?
If the locks were changed,
Yeah.
no.
So what happens to all the equipment, the refrigerators, the microwaves, whatever else?
I mean, it goes to waste.
Oh, it doesn't go to waste. What happens to it? What do you think happens to it? Don't help her. I see that. I appreciate the gesture. I like people get along, but
But if the tenant who comes after doesn't use.
what can the landlord do with all the stuff inside? Sell it. At common law, one of the attributes of self-help was that you could sell the stuff inside the house, right? To make up for past rent. You could actually sell their stuff, basically pawn it, right? For whatever value it is, and apply that towards the rent. And there's no obligation to get a good deal. You can just toss it for whatever money you get to pawn shop. So the self-help was a very brutal, unfair mechanism. So you can imagine this business owner says, well, maybe if I'm getting evicted here, I can bring my oven somewhere else and open a business somewhere else. But once you put the self-help rule in there, you can't even do that. Thank you. So Joyce, what does the court do with self? Okay. Why not?
I think because they say it wasn't pretending peaceful.
Oh, okay. Let me do that question first, Joyce. Joyce, why is changing the locks not peaceful? That seems very peaceful to me. There's no confrontation. He changed the locks. No one got to a fist fight. No one protested, held up signs calling them fascists, right? How? Sorry. Well, why is that? Why is that not a peaceful act?
I think the court mentioned that it was only peaceful because he
Good.
wasn't there.
Good.
But he just got lucky. Basically.
Yeah. Okay. So Joyce makes a good point. If she was there when he was changing the locks, what do you think would have happened? What's that, Marcos? What are you doing with that little
I was just
stretching?
yeah.
Kendra?
Well, could you not argue that there's a police officer there, so they could have prevented anything that was like violent from happening?
This is like if there's a Black Friday sale and only one sweater left.
But if there's a police officer there,
They're cops at Macy's, right? Yeah. People. Example, they
It was possible that it would happen.
I got an example. Has anyone ever seen? No, I got a better example. Has anyone ever seen a car getting towed, and the owner shows up?
Oh, yeah.
Oh, see, I told you a better example, right? So you've seen this, right? Where a car is getting towed, and they're about to put the thing on it, and the guy's like, "That's my car." Have you ever seen someone jump into the car and try and like get in it, and they just drive away with them?
Yeah, I was just.
Oh yeah, okay, yeah, go ahead.
On a South Beach tow, you'll definitely see a lot of.
Is that? Oh, that's one of those reality shows. So imagine, right? I mean, it's not a perfect example, but basically the tow truck guys, they're armed. They're usually licensed to carry, and people try and jump in the car. Actually, that once happened to me. I gave the guy $100 to let my car off, and I drove away. That worked. Just give him cash. They don't care. He actually let my car. I was actually. You'll never get back in there. And that means all of your stuff, valuables, jewelry, right? Whatever you have in there can now be sought off for pawn shops. Kendra.
I'm still asking though, like, what if a police officer was there to like prevent
Do people not like try and physically interject themselves? Do you think a cop could actually stop that?
Yeah, that's what they're supposed to do.
People can still do it.
Yeah, mass.
People
But they're
can
just
still
yeah.
get violent.
Yeah, I think there's still, even with a cop, the people act irrational. They might engage in acts of violence. Can you imagine, the woman says, don't change the locks. Like, she stands right there like this, and she, like, she forms a human chain around the door or something. You're laughing, but, this woman was losing her business, right? This is not a funny matter. This was her livelihood, even though it was rat infested, right? But this was her livelihood. And this guy's trying to shut her out, even though she has a 2-year left on her lease. So, I mean, there's some value here. So, yeah, Kendra, the short answer is, even if the cops were there, I think there still could have been an altercation. People do dumb stuff when they're angry, and the self-help lends itself to dumb stuff happening. Okay, with me. So to Joyce's point a few minutes ago, this was not a peaceful lockout, right? Even though it was a lockout, it was only peaceful because the woman wasn't there. If she was there, it would have gone down very differently. But now, Cheyenne, assuming that this was not a peaceful act of self-help, is self-help permissible now under the law in Minnesota? Why not? Okay, why do they want you to go to courts and not just work for them, right? Why do you want people to challenge the courts?
And they're trying to make the landlords where they can't just go around and do whatever they want to do.
Okay, very good. So the court identifies a few different reasons why self-help is bad, right? One is a result of the breach of the peace. You don't want violence. You don't want the cop having to, separate the landlord and the tenant when they're trying to change the locks on them. Another reason, they say that the landlord can't be a judge of his own rights, that there might be a dispute of whether in fact she's operating the land in a lawful manner. In this case, we had the breach with the alterations. That one's probably pretty easy. But with the code specs, that's actually somewhat of a difficult call. And in fact, in the state, there's actually criminal penalties for unlawful eviction as well. There are also issues of lost profits. What if they shut her down and she lost profits? How do you assess that? So as a general matter, they say go to the courts. And there's now a remedy, at least at the time in Minnesota, called a summary process or summary eviction. It can take as little as 3 to 10 days. So if you can wait like basically a week or two, you might be able to exclude them without having to go through forcible means. So as a result, the court adopts the modern rule, right? It's not retroactive, but subsequent to this decision, only lawful means to dispossess tenants, right? Meaning you can't use force, you have to use a judicial process. If they surrendered or abandoned property, it's a different story. But here there's no indication she abandoned the premise. Therefore, the lockout was wrong as a matter of law. Julian? California courts, they make the rulings retroactive. And I'm usually up here complaining, saying, wait a minute, that's not fair, right? How are you retroactively changing all past leases with this new regime? So this is a little bit better than that. It's like, well, we're not going to affect all actions that passed. We will only affect it going forward, plus this guy. So he's the guinea pig, right? So to Jolene's question, let me ask it to Mass, I think you're next. So you're a lawyer for the landlord, right? At the time, your client says, hey, she's got these health code violations. I don't feel like going through this process because I have a new tenant waiting to move in next month. Can I just change the locks in her? What do you tell them? Before, when this actually happened? What's your advice? Always pose this question, right? You give advice to a client based on what the law is at that given point.
Oh, well, if it's at a given point, then no.
And then the court, the highest court of the state, reverses that and says, no, 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 we're abandoning common law rules. We're going, this other direction. I think you're actually on you're safe, right? Unless Sean Handy's your client as well, I think you're in pretty good shape. Someone actually asked me that in comm. I was like, no, I want to talk what's done. But I think you're in good shape because you gave advice based on the law as it exists at the time. I think you're probably okay. Any non-Michael Cohen questions? I already did this in common law. I don't want to do it again. Spent like 15 minutes on it. Is that Michael Cohen? No, massive. So.
And I don't know if this is necessarily relevant to what we're talking about, but are there any instances where the law or courts will interfere when a landlord is not taking action against his tenants?
What do you
when
mean?
he should be?
What do you mean taking action?
Okay, well, I have an example, I guess. We had some neighbors, and they were pretty violent and loud, and neighbors throughout the neighborhood called the police on them multiple times, and because the police had visited them within a number of times within a short period, they had to go into municipal court, and they had to either pay a fine or they were given a certain time period to move out. And the landlord was told
Are you asking, can a court force a landlord to evict tenants? Is that your question?
I guess so, yeah.
So basically, the landlord's sitting by while these people are making a commotion in the neighborhood.
Yeah, obviously, they're saying that a landlord should, what's the word I'm looking for? In a normal situation where the landlord is wanting to evict the tenant, they need to consult the courts.
Well, I mean, you can go to court and say the ground for eviction is that they're making a lot of noise, and then the court would have to determine, is that in fact correct?
But what if the landlord wasn't doing that?
The landlord doesn't care, the guy's making a noise. So, I mean, if you're not the landlord, you can't evict someone, but you can have them arrested for disorderly conduct, and that's a good sign. But if they don't want to be evicted, you're stuck with them.
Like the landlord she lives in Houston, and the house that she
Yeah, you can ask me details later. I'm probably not going to give you advice of how to get rid of your noisy neighbors.
I'm
But
just curious.
yeah, it's a difficult situation because if the landlord does the neighbor is standing to do that.
Yeah.
Shane, who's your hand up?
Yeah,
And Andrew? Well, because under the common law rule, it wasn't clear if self-help was prohibited, right? That maybe this was a peaceable act of self-help, and here they said no, it wasn't peaceful. Andrew?
I was just going to say that in an HOA, homeowners association can have a court interject.
Yeah, because they're privity. They're in relationship with the tenant. Some HOAs don't even allow leases. That's only for ownership. Yeah, Brittany, go ahead.
Would it be a nuisance issue for the people who live there, and would the court be able to?
That's what I was going to tell
injunction
Madison
for that?
after class. Yeah, so the neighbors can probably petition for an injunction to prevent the nuisance, and then you have them held in contempt if they keep making the noise.
Would that
But the actually the landlord and not the tenant, right? So it would be difficult to even join it. I mean,
kind of stop with the landlord to just
I
address it?
think the injunction to stop making the noise is not to make them move out. Like I think it's an extreme remedy if someone's making a lot of noise so they have to leave their home. I mean that's a pretty serious remedy. I don't think the court would issue it. Thank you. Other questions? Yeah.
Do you think it's possible that the landlord in this case just saw this as an opportunity to make an efficient breach and just
Which case? You talking about the restaurant case?
yes, and just saw it as a sunk cost that he was going to have to pay to be able to get the preferred tenant in.
Oh, that is willing to pay the cost of wrongful eviction. But their legal fees, paying the other side's fees, so it's very expensive. You have to send her some salmon wrapped in wood or whatever, right? And the other case makes this point a little more clear, but like, litigating is not cheap, my friends, right? Litigating a case up to your state's highest court, hundreds of thousands of dollars, right? And this was back in the 70s, right? It's not a cheap enterprise. You want to litigate a case to the Supreme Court, might be $10 million by the time you're done, right? Not cheap. I do it on the cheap, but the real lawyers charge a lot. I do things for free. Things I like. All right, what else? All right, so most states today have adopted what's called a summary proceeding, right? A summary proceeding. And the summary proceeding is designed to replace what used to be called self-help. And the idea of a summary proceeding is to give someone a fairly fast judicial resource to deal with ejections. But it can't be so fast that the tenant is denied the due process of law. So in most states, there's a specific procedure. So I have up here what's called the Texas Code governing jurisdictions. From start to stop, about 3 weeks on average. It could take more, it could take less, but about three weeks. Let me break it down for you. You first need to give notice, right? Notice must be in writing, saying you are in breach of the lease. And you have to give them 3 days notice before you go to court. This is a good thing, because very often these sorts of disputes can be worked out amicably. So say, they say you didn't pay your rent. Like, oh, I paid, it got lost in the mail. Okay, probably not true, but they'll scrounge up the money and pay for you. Let's say I am evicting you because you made changes to the structure. No, I didn't make any changes. It just looks a little different. All right, whatever, but they can maybe fix it. Or I'm evicting you because you didn't do X, Y, and Z. They go do X, Y, and Z. So the 3 days is like a cooling off period, right, where you can perhaps smooth things over and work it out, friendly, no courts, no record. Oh, this is mentioned in the reading, but there's a downside to bringing an eviction proceeding against someone. It creates a record for the credit history. And this is not a trivial concern, right? Because if you've been evicted, you're going to have a very tough time finding an apartment in the future. So in some cases, it's a 3-day period where you can say, all right, I'll get you the money. It avoids having a record for your credit score. There are certain rules of how you have to give the notice to make sure the person actually has it. So you get 3 days notice. Okay, then you file in court. And then there's about 8 to 10 days for a citation to be served. Okay? What's a citation? That's something from the sheriff or the local law enforcement saying you have been served notice of eviction. Right? There's been an action filed against you. You need to have at least 6 days notice for the hearing, but usually 8 to 10 days. Saying 10 days from today, there'll be a hearing in such and such a court regarding your eviction. But you have to have at least 6 days notice. Usually it's 8 to 10 days to give you a little bit extra time to think about it. Okay? You can get a lawyer. Maybe yes, maybe no. 5 days. I'm sorry. Usually they're not appealed because the findings of the trial courts are generally affirmed. There's very rarely a successful appeal. So let's assuming you don't appeal. The constable or the sheriff puts a 24-hour vacate notice on the door. Basically, you have a day to move out after the appeal. And then after 24 hours, you're done. So 20 to 23 days, depending how you add it up, is generally the minimum time it takes to evict someone in Texas. That's quick, 20, 23 days. In D.C., the District of Columbia, the average eviction time is 114 days. What was that? Holy smokes, yeah, that's exactly what you said. 114 days. Only I get to curse in class, right? Yeah. In Massachusetts, it can be up to 2 years. And that cost is factored in, right? If you're a landlord and you know it might take you 6 months to evict someone, you're factoring that into their rent. You'll demand a higher security deposit. There are various other mechanisms by which landlords can recoup that cost. So this is not free, right? Imposing significant costs on removing someone makes it that much harder to rent the place in the first place. And indeed, they may require stronger credit history to rent. So make it harder for people who are on the margins to get an apartment in general. If you learn nothing else from me, everything has a cost. Everything has a cost. When you make something easy on one side, it makes it harder on the other side. Okay. So any questions of the summary proceedings? Anything? No? Okay, move on. So the next set of questions concerns the tenant who abandons the premise and what's called a duty to mitigate.
Applied for and was approved for a lease with Sommer, and was supposed to be 6 weeks free, and then I'm given 690. And before he began, he sent a letter to the landlord saying that he was supposed to get married, but he
Aww.
no, he couldn't move in.
Tragedy, right?
Yeah.
Now, we also know, Shana, what was his job going to be after the marriage?
Law student.
Yeah. So, usually people get divorced after law school, not before law school, but you know, this is how these things go. He had signed the lease, hoping that mommy and daddy would be helping to pay the rent. The engagement unfortunately broke off. He never even took the key, right? He never even showed up. And he said, look, I will forfeit, I will surrender whatever money I paid you. Please have mercy, right? Please have the kindness to let me out of the lease. Okay. Landlord did not live on the lease. In fact, Gabe, what did the landlord do that really
Go against the common
They're about to reverse the common law. You know what's going to happen. You don't have to read the damn case. You know exactly what's going to happen. So it makes your work a little bit easier. So what really made the court angry here, was the fact that someone came by, offered to rent this specific unit, and the landlord said, "No, no, not available. Someone else has a lease for it. Go take this one. Now, Lauren, if you're the landlord, right? Why would you do that?
So we can still get the money.
So you could what?
Still get the money from the original.
Good. He wants a double dip. Right? Think about it. Let's just make an easy example. You have two apartments. One of the apartments had this lease on it with this lawsuit. The other one's empty. You can get rent from both apartments in theory. Now, let me ask a follow-up. If this poor kid wasn't able to pay his rent, why did the landlord think that? No engagement.
Lost money.
I'm sorry?
I'm not sure.
What, Austin?
He'd be a lawyer.
Ah, there it is. He'd be a lawyer soon. What's the expectation, Austin?
He'd be getting fat stacks.
He'd be getting fat stacks? Is that what you said? Oh, man. In English, please?
He'd be rich.
He'd be money. Yeah, money. So, I mean, it's not in the facts, but I'm, speculating here. He knew this guy was going to law school, right? He's like, okay, you know what? I'll let this sit open for a year and a half, and I'll sue him eventually for damages. Might go to court for a while, get a judgment against him. I'll eventually collect, right? Screw the law student. He'll have money in the future. So, notwithstanding his plea for compassion and understanding, the landlord said, screw it. I want to double dip, and I want to get my money in. And at the time, Lauren, was there anything wrong with what he did? Did the law have any problem with his actions here? At the time, right? You're the lawyer for the landlord, and the landlord asks you, Lauren, do I have to rent out this apartment, or can I, just leave it empty for a year or two?
I think we'll at the time the law side of the landlord.
Yeah, and in fact, there was a court case from New Jersey, was the Court of Errors and Appeals, or whatever it was called, that said you're not under any duty to mitigate, you're no duty to rent it out. So again, Lauren gave correct advice to the lawyer, to the landlord, but the advice did not last long. That was the first case. It was the Sommer's case. So another case was called a companion case. And what's a companion case? You ever heard that phrase? What do you think it is in this context? Yeah, exactly. The Proceedings case, right? Proceedings. It's basically the exact same facts. Often courts will do this, right? Well, they'll take several cases.
Like a prospective
Good.
tenant.
That someone came by, was willing to rent the apartment, and he said no to them. Were those facts present in the second case, the Proceedings case?
No.
Well, actually, we don't know, right? And this is an important point. The court says, well, we don't really know what happened there. Send it back down to lower courts, and let's do maybe some discovery to determine was someone willing to rent it. So the reason why the court does this is like, okay, where there's evidence that someone wants to rent it, that's really bad. When there's no evidence, we'll remand it anyway and waste another couple of years on trial to find evidence that probably doesn't exist, right? By the way, I don't know how much discovery had to have happened in this case. What I'm guessing is the landlord was put under deposition, and he was asked, did anyone come by to rent it? Where I said, yeah, I think so, maybe. Right? Who actually keeps track of these sorts of things? That people who don't rent an apartment that could have. I don't know. Not on the record. Right, so those are the facts, right? So in the first case, the Sommer's case, the landlord sued the tenant for almost $8,000, which was the total amount due for the 2-year lease. Okay. It was a mid-trial. notions of justice and fair dealings requires ruling for the plaintiff. The appellate court reversed, saying, no, 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 there's a case on point here. And the landlord has no obligation to mitigate damages. Then it gets to the Supreme Court of the state. So how does the Jersey Supreme Court rule on this issue? Is there a duty to mitigate? Very good. Why does the court hold that there's a duty to mitigate on behalf of the landlords? Why is there a duty to mitigate on behalf of the landlord? Arlette?
Is it whenever they're discussing, like within contract law?
Good. Well, why is there a duty to mitigate for contract law?
So basically, you are not being more burden on the person that breached whenever you could have already been getting money through that.
Very good. And this is what we describe as basic fairness, right? Basic fairness. You don't usually have duties to mitigate in property because it's generally a very unfair class. Okay? But the issue here, right? The issue here, was there an act of unfairness? And the court holds that there was. And because the duty to mitigate was not complied with, the landlord loses. And not only does he lose, the landlord is on the hook to pay fees. And I think the book said like, what was it, $500,000 in fees? He has to pay that. So think about it for a minute. This guy thought, right? This guy thought he was going to be saving some money, $5,000 or $6,000 by letting the apartment sit empty. He had to pay $500,000 in fees. The other side. That's nuts. And the law student who then became a lawyer basically did it on his own dime. So he didn't pay a damn thing. Right? Whatever printing costs or anything else. Okay? Yeah, Megan.
So is the plaintiff essentially let off the hook for breaching his lease?
Is the plaintiff let off the hook for breaching speech? Yeah. Basically, well, the plaintiff is all. Oh, let me ask you, Megan, this question: what is the plaintiff? So, what's the tenant on the hook for? What does he have to pay? How much damages does he have to pay? Right, the apartment wasn't even empty for 2 years. Let me say a little bit clearly. The lease was for 2 years. He did not pay all the rent. At a certain time, someone came along, was willing to rent the apartment. Right, Megan? At what point was the tenant no longer liable for rent?
Up until there was a prospective.
Yeah, exactly. Right, so the idea is this. The duty to mitigate kicks in right away. And once you had an opportunity to rent it, by that point you can no longer hold the plaintiff to be accountable. The tenant cannot be accountable anymore. The tenant's only on the hook for rent until someone else is willing to rent it. Now, what if the person wasn't really interested? Maybe you can have a factual dispute. But at that point, that's not really clear. questions on that? Yeah, please go ahead, Maria.
So I would have thought that in the companion case, the existence that was really important was the fact that the defendant took possession of the apartment and was actually occupying it.
Oh, why is that important?
I don't know, it just seems like it's such a big difference between not even being.
Well, let me ask you this. When you signed the lease, was there anything stopping from showing up? Right, he had legal title to the property. Think of the case where he showed up and there's a holdover, right? So it was his, even though he never showed up, even though he never took the keys. So I don't know if that makes a big difference. But the big difference here is there was evidence that he tried showing to someone and someone was interested in the unit. Kendra?
Does Texas follow this or the common law?
Hold on, I have my notes. I think, yeah, no, I think Texas does impose the duty of mitigating landlords. I think it's a similar rule. Okay. Well, it's the Texas rule. It's a modern rule for Texas. Okay. In that case. The ex-fiance signed it. I also don't know why the parents didn't co-sign the lease, because if this, think of it this way, right? If he was a law student, he basically had no income. I suspect that the parents would have been in a better position to co-sign the lease, or at least the in-laws. So I don't know why they didn't go after him. Maybe only the guy signed the lease. I don't know the answer.
So if the parents would have signed like as a grantor, then they legally could have gone after them?
Andrew shaking said yes. Yeah. Yeah. I mean, as a general matter, if you're a landlord and you have a tenant who has zero income, you're going to make sure that the parents are on the lease, and you go after them. I don't know why that didn't happen in this case, even though the family had rifts, or whatever. Okay. Yeah, Andrew.
I wanted to say something with the forcible reentry in Texas. There's an exception.
Okay.
I think it's 30 days after the landlord has started the initial process of summary proceedings. If the court hasn't, if the judicial system hasn't,
You guys help?
you can't do self-help, but you have to have police officer a time limit on it.
Right. So that's if it drags on forever and the courts don't get their act yet. I suspect that's right. All right. What else? All right. That's all I have for today. I'm done. I will see you all on Thursday.